All right, I want to bring in my special guest here in the studio to help me discuss what we saw in that outburst. We have criminal defense attorney Michael Bixon, and we have Lieutenant Colonel Adam Lee with us. Thank you, gentlemen, so much for joining us.
Thank you.
Okay, you saw that outburst, and that was just one of two. We're going to show you the next one, but just want to get the reactions, seeing that, his behavior, your thoughts, please. Colonel, we'll start with you, please.
I believe you could see the disgust on his attorneys' faces when that outburst occurred. It was something that you never want your client to do if you're trying to defend them on a case where they might possibly get the death penalty. And so it's almost as though he's walking his way down the green mile, so to speak, if you to use a term from the movie.
Right.
So it's just unimaginable that you would allow that to happen.
To behave that way. Michael, your thoughts?
It must be beyond frustrating for his defense team to, be trying their hardest to keep him off the death penalty, and at the same time, at every chance he gets to interject, he's doing it, and he's making it harder and harder, and especially when you're trying to mitigate, and his brother's up there, and then he just tears it all apart. All the sympathy that his defense team tries to build up for him just tears it all apart over and over and over.
He's not making their job easy.
Oh, God,
I
no.
feel for that defense team. These are very competent lawyers who've done so much, and he is so combative and insulting to them. I think jurors are picking up on that. I think they have through the guilt phase, and you've watched this trial closely. Have you thought the same thing, that they're probably catching that, how he treats them?
I have. I think this has been very exhaustive for the jury. I'm sure they are ready to have this done and over with, as well as his attorneys. They're ready to go. It's really making everyone tired, I believe.
Right.
I'm tired just watching it myself.
Right.
It's just ridiculous.
Oh, yeah. And there's more. The second outburst was even worse. Let's take a look at this one. This one happened when Tim Gravett, who's a prison consultant, was on the stand testifying.
Mr. Nelson, talk with your attorneys, and then your attorneys. I'm going to, Mr. Nelson.
Tackling like an idiot.
Mr. Nelson.
Bastardizing the due process of this trial.
Mr. Nelson, you have attorneys. You need to take a moment to talk with your attorneys.
I'm demanding that we have a mistrial right now. He called me a racist in front of 5 black jurors. Mistrial now. It's been through enough.
Your Honor, may we have
Stick
some
over
time in
it.
the side room here to have a private conversation with Mr. Nelson?
State have any objection to that?
If the idiot was-
All right, hold on, Mr. Nelson.
Now, I'm going to have when do I get to testify?
Mr. Nelson.
I'll let
Mr. Nelson. Mr. Nelson. Do I have your attention? Okay. Ms. Simmons has asked for a moment to talk with you privately. I'm going to grant her request, and you're going to have that opportunity. You need to follow the deputy's instructions so they can facilitate this. Okay, go ahead.
All right, looking at that one, Michael Bixon, I want to turn to you. You're his attorney. What are you thinking right there at that moment?
God help us all.
Right.
Really, there's no doubt about what the end result of his life experiences, his childhood has led to, right? He's a terrible person. Nobody's going to argue otherwise. Maybe what led to that not being his fault. Maybe you can mitigate on that. But it becomes so overly apparent to everyone in the courtroom, especially the jurors, what kind of human being he is when he's sitting there and he's making these kind of outbursts in front of them to his own defense attorneys. And so the only thing you can do is acknowledge who he is and what he is, but try to mitigate it with what he's been through. And even then, it becomes so much harder when you just see who he is over and over and over through these outbursts.
And Lieutenant Colonel, I want to draw on your experience. Look at how the deputies were just kind of closely moving in toward the defense table, and they've got quite a job to do with him as well.
I did notice that. I noticed how they positioned themselves around him once that outburst occurred. They don't know at any moment when that might become a physical situation, and they may have to protect themselves, him, as well as the attorneys. He seems to be getting agitated with his attorneys, so I would say that possibly his attorneys may be afraid of him.
Right.
He's the kind of guy that brings about fear.
Sure.
In the way his tone and the way he talks. He was angry enough, or he appeared to be angry enough, to lash out physically at that one moment when he was talking to the attorney about getting the trial dismissed.
Sure, the mistrial movement.
Mistrial,
right,
yeah.
right, absolutely. And Judge White, the judge presiding over this case, has been very, very patient with Nelson, as we know. He was not having it at that moment. Let's listen to what he had to say to him.
Mr. Nelson, have you had a chance to talk with your attorneys?
They've explained a lot to me, yes, sir.
Do you have any issues of proceeding at this point?
No, I don't have any issues at all, sir. I'd just like to proceed, and I was getting into my feelings, I guess you'd say. It won't happen again.
You recall our conversation previously when you made an objection, I believe? Do you recall that conversation?
I do, Your Honor.
Do I need to repeat that conversation, or did you just forget what I said?
No, I remember very well now. Won't happen again, sir.
Do you understand, although you're on trial here,
Yes, sir.
that if you violate the court's orders and you do not conduct yourself in a manner in accordance with the court's orders, which includes but is not limited to the decorum policy, that you can forfeit your right to be present during your trial and I can have you removed from the courtroom? Do you understand that?
Yes, I do, Your Honor.
Have you had a chance to talk with your attorneys about that?
Yes, I have.
At this point, you've engaged in 2 outbursts. Are you confident that you can comply with the court's orders and continue to do as you've been doing, which is sit here at the defense table, work through your attorneys privately in private conversations to convey your desires to them as you have been doing, and otherwise speak only through your attorneys unless the court asks you for a direct response? Do you feel confident you can do that as we proceed?
Yes, sir.
Do you need to talk with your attorneys or talk with the court about any clarification on what the court's expectations are regarding your behavior here in court?
No, sir.
Wow, I have to hand it to Judge White. I thought he handled that very, very well. Michael, want to get your thoughts. What did you think of how the judge handled that
I think he
situation?
did a great job. I mean, you could tell he was irritated, and rightfully so, right? If you are doing a murder trial, and especially with the death penalty being on the line, as a judge, you want to make sure that everything is done according to the rules of the court, because the last thing you want is there being a mistrial or some issue coming up on appeal that you could have prevented just from like an attitude basis from the defendant. And so he's trying to do everything he can to make sure that this case sort of follows the rules of the court to make sure that it's done properly. And it becomes really difficult when you have these outbursts and these crazy moments that I think Mr. Nelson's sort of trying to throw out there.
Thank you. Lieutenant Colonel, your thoughts on how the judge handled
I
that?
believe just what Michael said, the judge cannot afford to show emotion. As agitated as he may have been, as agitated as the prosecutors or the defense attorneys, as anyone would be inside the courtroom, they cannot afford to show their emotion because that may influence the jury one way or another.
Right, right. You know, the judge has really, to your point, Mike, about how he really, it seems evident he's making a very clear record with everything in this case. I noticed at a couple points during the guilt phase where he would ask everyone if they acknowledged the presence of the jury. And I know where I practiced in Pennsylvania, that wasn't something that was done. And I asked an attorney who said in Georgia that's not commonly the practice either. But it just seems like he's going through every step he can to make sure this case doesn't come back. And I feel like he's been very respectful to the defendant. I mean, you could see he certainly was agitated, losing his patience. That was about as visible as that was, for lack of a better word, from Judge White. But I do think he's been very cognizant of the fact that this is a guy who is well aware of the system and almost enjoys making a spectacle of himself and being the center of attention. Do you agree? Do you feel like some of this, it's almost like a game to Scott Nelson?
It certainly is. I think he's enjoying it. This is like a stage show for him. He wants the appeal. He wants to be able to come back. He wants to be able to be out and away from a prison environment. And this creates an outlet for him, I believe, being in that setting, being away from prison.
Right.
And so most certainly he wants to be able to have another trial because that'll be time away from his prison environment.
What do you think, Michael?
Well, not just that, we heard during his outburst what he wanted. When do I get to testify? When do I get up there and see my piece, right? I mean, you can tell that's just running through his mind. I can't wait to take the stand and get another 60 seconds of fame, no matter how much that might cost him in the long run. Because we saw the prosecutors tear him apart when he took the stand last time.
Right.
And it didn't do anything to help his case. But even with that happening, he still wants to get up there. He still wants to go through it all over again, you know, which to me is even crazier considering it's the death penalty phase for his trial. And there's nothing he's going to say that's going to help him.
What are we going to hear that's going to be different?
Right.
Absolutely.
He'll be telling the same story over again, maybe in a different way.
Wonder, you did ask me a short time ago who he might blame. That's a great question. He blamed Julio Dominguez, his federal probation officer, during the guilt phase, and who knows, maybe he's going to blame his family for his upbringing. And you know, we certainly will get into that later. It's wonderful to have you gentlemen here on the show to share your expertise. Thank you so much. When we come back here on Court TV Live, we will have more live coverage for you of the penalty phase of Florida versus Scott Nelson, and we'll also be taking a look at some of the most explosive moments of this trial so far. Don't go away.
You've used your position and power to pull the wool over everyone's eyes, but I know who you really are.
And who's that?
A killer.
You make it sound so ugly.
Saints and Sinners premieres Sunday night, 9/8 Central, only on Bounce.
Court TV has returned to television,
bringing you the cases that change our world. You'll be there as history unfolds and justice is served.
The all-new Court TV.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us on this Friday. We continue our coverage for you of the penalty phase in the case of the state of Florida versus convicted murderer Scott Edward Nelson. After 4 hours of deliberations, a jury found him guilty on all counts. Now they must decide whether Nelson should spend the rest of his life behind bars or pay for his crime with his life. Well, one of those jurors was dismissed earlier this week after another juror told the judge that he said he was unwilling to vote in favor of the death penalty for Nelson. They shouldn't have been discussing the case. Nelson brutally murdered Jennifer Lynn Fulford and admitted to killing her when he took the stand during the guilt phase of this trial. Court is dark today, but the defense attorneys are very busy. They're planning to depose 3 more potential witnesses. And of course, the largest question is whether or not Scott Nelson will choose to take the stand again. For now, let's take a look together at another explosive moment that happened in the courtroom when a juror got himself into a little bit of trouble. Let's watch.
All right, juror 218. And you are on seat 1, correct, sir? All right, sir, an allegation has come to the court's attention. It's alleged that you're in the jury room this morning. You said words to the effect of, you would not vote for the death penalty unless he killed 10 other people. There is no point in discussing further, or words to that effect. Is that correct?
I said it would be very important for me to go after the death penalty after everything that I didn't. I wasn't asking for anybody else's opinion. And what was the last part of that too? Because I don't think that was.
Why don't you tell me what you said?
I forget why it was brought up, but I basically said, with everything I've heard, I don't know if I can go after the death penalty.
Anything else that you recall that you said this morning in the jury room?
Not to going further on that.
Earlier, just a moment ago, sir, did you say something to the effect of, I don't know why it was brought up?
Well, how the context began.
Do you recall someone else talking about that issue or any issue related to this penalty phase?
Not the penalty phase. It wasn't anybody else talking about it. I don't think it was. I didn't just come out and say, why are we doing this? I was just making my point known that I'm gonna have trouble committing somebody to death for what I've been told already, and that it wasn't me trying to persuade anybody else in the room. It was just I shouldn't have said it, obviously.
Do you recall the court's instruction multiple times to not discuss this case amongst yourselves or with anyone else?
I do.
Why did you then say what you said?
I believe there was discussion about how long the case would take. I don't recall who was saying that it's going to take a while, and I think at that point I was like, I think that's maybe why I chimed in, saying that I don't see what 2 weeks based on your timeline is.
All right, Lieutenant Colonel, I want to go to you first. What do you think that juror was thinking right there as the judge is asking him those questions?
He was thinking about how I really messed up. Mm-hmm. You know, I'm getting. He knew he was probably going to get dismissed at that point, based on the set of questions being posed to him by the judge. So he knew it was over with. The gig was up.
Mm-hmm. Right, Michael.
Same. You know, I think the judge was sort of going down a line of questioning. One, to find out how much and if the other jurors had been sort of tainted by what he had said.
Right.
But you could tell another part of it was just the judge really being irritated and frustrated. I mean, you don't want to get this far along and then, you know, because there's no mistrial for the state if they don't actually, you know, do the death penalty.
Sure.
That's it. So they don't get a second shot at it. And they came so close to losing it just because this one juror had already made up his mind. And it's certainly possible that others have, they just haven't spoken out yet.
Right, right. You know, something I think is important to explain is when you think of the jurors being together and all that, you think, oh, they must be talking about the case all the time. But that's really against the rules, isn't it? You know this, Mike. Can you explain,
yeah.
Give us a little bit of a tutorial on what's permissible and when they can discuss?
Yeah, I mean, so depending on what stage in the trial you're in, there's certain things that they can talk about. And look, it becomes hard because they become so familiar with each other. This case has gone on for a while. They become to know each other, get comfortable, and they start talking about things, right? This is not something you can talk about. You can't talk about the fact that you're not going to give him the death penalty no matter what happens after this point, right? You can't do that because at that point you've already made up your mind no matter what arguments are put forth, and that's not allowed.
Exactly. And Lieutenant, oh, please, go ahead.
It really depends on how serious you take your job as a juror is, because some jurors may really follow that order to the letter and they truly believe they want to do a good job, but then other people may not take it so seriously because it is an honor system. You know, there's not a camera following you around to make sure you're not talking amongst yourselves. So by it being an honor system, you have to really take your job seriously in order to get through this. And some people might just not think it's all that much, so they'll tend to try to talk, and then another juror will tell them, hey, we can't talk about that. You know, you need to shut up. I can't listen to you.
Right.
You know, so.
Good point. And after the judge was made aware of this, we want to show you how Judge Keith White dealt with juror number 218.
Juror 218, the court has determined that you are going to be excused from this jury because you have violated the court's order. In a moment, I'm going to excuse you. You're going to leave your notepad. You're going to actually give your notepad to the deputy. The deputy will assist you getting your personal belongings out of the jury room. Sir, you shall have no interaction with any of the members of the jury. Do you understand?
Yes, sir.
That's an order. Do you understand? You must follow it, or the court could hold you in contempt.
Yes.
Okay. So like I said, the deputy can assist you getting your personal belongings, no communication with any of the jurors. Give your notepad and your pen to the deputy. Thank you.
Apologize.
All right. And the deputy, well, you are excused, sir. Thank you.
You heard the judge off on his way. He sent juror number 218. He was replaced with one of the alternates. Was that the right move, Lieutenant Colonel?
Absolutely the right call. This could have been a disaster if that had happened. I'm sure the defense doesn't like it. You know, they would prefer to have had that person still there. I mean, that was their shot. He would not have voted for a death penalty. So I'm sure that was something that they truly did not want to happen.
And maybe so they didn't get in the vetting process. Did you think of that, Michael, during voir dire? How did this guy get through voir dire?
So it's entirely possible that even through voir dire, that maybe he hadn't made up his mind about, because I mean, look, how many people really sit there and think at home about the death penalty and whether or not going into a trial, which way they're going to go? And it might not be until halfway through the trial that they really do make up their mind. Maybe that's the case. Maybe he already had it before you even went into this case. But the cold, hard reality is people lie all the time. When you're doing something like voir dire and you're questioning jury members about how they feel about the death penalty and whether or not they already have made up minds about which way they would go on it, people lie. I mean, that's why I think it's more important to educate during that process, because you can't really get to know someone in the span of an hour or two asking them a couple questions which way they're really going to go on something. And again, people lie. So the best thing you can do is educate and hope that people don't go into it with their minds already made up, whether you're defense or prosecution. Because you need them to be able to listen and sort of apply the facts to the arguments that they're listening to.
Right. Michael Bixon, Lieutenant Colonel Adam Lee, it's so great to have your expertise. Thank you so much. You're going to be staying with us throughout the show, and we appreciate that. And coming up next here on Court TV Live, our anchor team will be joining me for our daily sidebar. We'll be discussing which witnesses may have had the biggest impact on the jury. Did they testify for the state or for the defense? And perhaps the most important question of all, will Scott Nelson take the stand again, and should he? Also, big legal news today, Kevin Spacey's accuser dropping the civil lawsuit against the actor. We'll be back with more legal analysis for you right after this break. Don't go away.
Tonight on Court TV.
8 years ago today, Casey Anthony was found not guilty of killing her own daughter, Kaylee Marie. It was the trial of this century.
And you will go to jail for child neglect for the rest of your freaking life.
And we're taking a special look back at the most memorable moments of the Casey Anthony trial with the man who presided over it all, Judge Belvin Perry.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
Watching Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us on this Friday. I'm here with our incredible anchor team for your daily sidebar. Your D2LD, Vinnie Politan, and Seema Iyer on the couch with me to talk about the biggest things going on in legal news. First, we're in the penalty phase of the case we're covering, gavel to gavel. The state of Florida versus Scott Edward Nelson. He has been found guilty of murdering beloved nanny Jennifer Lynn Fulford. Now the jury is deciding whether he should receive life in prison or die by lethal injection. The defense is currently wrapping up their case. Have they provided enough mitigating factors to convince this jury that Nelson's life is worth saving? Also, big legal news today, Kevin Spacey's accuser dropping the civil suit against the Hollywood actor. Spacey is accused of groping the man. We're going to get to that in just a moment. But first, we want to start with what witnesses have had the biggest impact in this case so far. I want to ask each of you that question. Which witnesses for you do you think are going to be most telling for this jury as they decide life or death? Udit, I'll start with you, please.
I'm going to say that Robert Fulford, I think, made the greatest impact with his victim's statement. Even though they're not supposed to consider this as evidence, we're human. We obviously know how impactful that can be. I thought he was really good. And for the defense, James Nelson, Scott Nelson's older brother, made the best impact. And according to Julia Janae, who's inside the courtroom, said that several of the jurors were on the brink of tears listening to his testimony. So I thought that was powerful for them.
Oh, absolutely. Yeah. Let's look at a clip now of Robert Fulford's testimony.
Jenny was loving. A list of things that Jenny loved could go on for hours. First and foremost, she loved her family. She loved people. She loved the holidays, and she loved animals. She loved life. She loved me. I will always love her.
That poor man has been through so much. The jury's seeing that it tugs at your heartstrings. Anybody on that jury would have to be feeling something watching him. I mean, do you agree? I think hands down he's going to be.
No doubt. And what you understand when you see him is who she was. You know, you see that this is a woman who found love, and he lost her. And to me, when you talk about what these cases are ultimately about, they're about the victim. It's a search for the truth of what happened to the victim, and then if that person is found guilty, what happens to that person? But again, it all reverts back to the victim. So I agree that his impact will be something that's difficult to overcome because of the realness of it. And sometimes that gets lost in these trials where you're talking about a victim and there's like no one there for the victim. I've covered cases like that, and it's like for a jury, it's almost as if it's not real, right? It's like theoretical that there was this crime and you have to look at elements of the crime.
Right.
Well, now you're talking about a real person who was lost, who had a life, who had a great life, who was doing wonderful things and was filled with warmth, and that came through. And I think that there's no way that cannot have an incredible impact on the jury.
Sure.
And I think what we didn't know during the guilt phase is about the epic love story between Robert and Jennifer, and that is that they met in 1994. They fell in love. They were together. They were this wonderful, inseparable couple. But then, because sometimes, timing's not right for love, they break up in 1998, but stayed in love and stayed in touch. But they went their separate paths. I mean, this really is a movie when you talk about these two. They went their separate paths. She obviously got married, had kids, and yet they still never got over each other. They reconnected in 2005, got married in 2010. This is what dreams are made of. And so in the penalty phase, we got so much more about this beloved Nanny than we ever thought we would know. And so I think Robert Fulford, and with her children, definitely made the most impact for the prosecution. And I agree with Yodit. I think James Nelson carries the day for the defense.
I'm with you both. Vinny, do you feel the same way, James Nelson? If anybody may have saved his life,
Sure,
might be him.
sure. But then there's Scott Nelson. And even if he doesn't testify in this penalty phase, right, we'll talk about that, but I believe there's no way to overlook his impact from the guilt phase in this part of the trial, because they can consider everything that's happened. They're not going to turn on blinder and say, oh, that didn't happen. No, it happened. He got up on the stand and he was who he was. And that may, in the end, be the strongest evidence for the prosecution. A reason why. We heard him, we saw him, we listened to him. His own words.
Right. Well, let's listen together to the words of James Nelson. And remember, when the jury was watching this, there were points where some of the members of the jury started crying. They felt so moved.
You also mentioned that your father was physically abusive. Can you give me an example of how he was abusive to you?
Well, it ranged from slapping and pushing to where I was hit with a 2x4 on more than one occasion. He would throw things at you. He would get you into a corner and he would beat you with a belt, and he would hit you with the buckle end of the belt. I grew up hearing my mother would repeatedly be saying to my father when he was doing this, don't hit them in the head. My father just lost control and he'd just keep going and going, and apparently until he tired of doing it.
I don't think anybody can watch that testimony and not feel moved, and it tugs at your heartstrings just like Robert Fulford's testimony does. And I think trying to look at it from the other side, I keep thinking, well, as horrific as that was, people have experienced worse childhoods and done better for themselves. So I wonder if some of the members of the jury, even those members who were crying and who really felt something hearing him and felt awful for what Scott Nelson experienced, are taking a step back saying, well, wait a second, as horrible as that was, doesn't mean you get to go out and kill a woman later in life. Your thoughts?
And the other part of it is the way he described it, he got it worse than his baby brother Scott, who was kind of like the favorite child. Don't forget that part of the testimony as well, that of the three boys, Scott was the one who got it the least, and the father was out of the house the earliest and was gone. So the abuse that's described there, it was bad, but oh, by the way, he's not a killer. The man who was hit by the 2x4s.
He might have gotten it the worst, the oldest brother, but he also moved out of the home so early on. And Scott Nelson was the one that stayed with his mother and had to take on the burden of having to support her emotionally and financially, which also caused more extreme stress for a kid at that age, right? But I do believe what you're saying, Julie. You have a point in terms of the jurors thinking that, you know, hey, he's not the only one that's gone through a tough time and still made it through. There are probably jurors who have gone through worse. And then there are probably jurors who can relate to what Scott Nelson went through as a kid and might have been the cause for why they were tearing up, right? Thinking about their own childhood. I think it's just a heavy burden for a juror to send someone to death. And if for anybody, even if it isn't for Scott Nelson, for James at least, because he was also someone that you could feel sympathy for. He's lost 2 parents. He hasn't seen his brother in 25 years. To take his brother away and sentence him to death could be a big deal for this brother who has health issues too. So I felt bad for him more than anything.
Sure. You know, another person I know we all feel bad for is Hannah Geist, Jennifer Fulford's daughter, who testified giving a victim impact statement. Let's take a look at some of what she said.
My mom was my best friend. I mean that in every sense of the phrase. We laughed hard. We talked to each other about everything. We held each other's secrets. We checked in on one another, and everything we did felt like an adventure. We bickered. We cried on each other's shoulder. She taught me how to dance, and we danced all the time. She taught me how to sing, and we sang all the time. We were there for one another, and we loved each other more than we loved ourselves. Because that's who my mom was. She loved in a way that made you feel like you were the only human being on the planet, and that love was truly unconditional.
All right, Hannah Geist there, just heartbreaking all the way around. You know, she seemed to be, and through no fault of her own, but, you know, kind of reading from the paper, and, you know, it wasn't as moving as Robert Fulford's testimony, at least for me. I mean, certainly was moving. My heart breaks for her. She was a little more composed, a little more together. Did you think the same thing?
It wasn't as impactful, I think, as being inside the courtroom, facing the defendant. The person that took your mother away, I think, would have been more compelling. I get that life, you know, happens, and, you know, of course, her son couldn't make it because he had, you know, young, you know, kids at home. But to be in the courtroom would have been way more impactful. But then again, you had, you know, James Nelson doing the video conference call too, and his statement was more impactful, I think, because he didn't have a script. He didn't have anything written down. So, you know, maybe if she just would have said it from the heart. And I get it, you know, you want to just stay composed and make sure that you're not, you know, straying too far off. But it just didn't hit home for me. I feel bad for saying that. Obviously, she's gone through a lot, but it just didn't make an impact like I thought it would.
Right. I know. I felt the same way. That's why I asked the question.
I thought Hannah Geist was very impactful, and especially maybe because I'm so close to my mother, and so, you know, that mother-daughter relationship and talking 20 times a day, and just, you know, putting myself in her shoes and what that type of loss would be. So I thought she was very impactful. I know, and, you know, to what you're saying, you know, a lot of times people will come into court and they'll read a statement, and there is something lost when they do that. They're standing, you know, in the well and they're reading from it. But a lot of people are not comfortable with public speaking, and this is a very intimidating venue. So I give her that, but I felt that Hannah Geist, for me, was more emotionally provocative than the brother.
Sure. What do you think, Vinny, between the two?
Well, it showed us another facet of Jennifer's life, right? We know that she's a nanny, and we know that she has this, you know, Robert, but then the jury said, hey, wait a minute, there's more to this. She raised wonderful children, and one of these children is, you know, going to have to get married without her mom there. She's going to have children that won't have their grandma there. So I think that's important for the jury to know, because again, it's impact. You know, how does this crime impact people? Well, we know what it did to Robert, broke his heart, and now generations of people in this family now are forever impacted by this, and it's terrible. And you don't always think of it that way, And for jurors, again, you're being bombarded by evidence and law, and sometimes you don't see the trees through the forest inside a courtroom. This, I think, got them to see the big picture.
No, most definitely. And some of the most impactful testimony perhaps came during the guilt phase from the medical examiner, the evidence he was able to put forth, the science and how she suffered before she died. Let's take a look back at some of what he told the jury.
Well, just the act of blocking someone's airways, their nose, and mouth, it decreases your oxygen, increases your CO2, so you can't get that CO2 out, and so that can cause anxiety and stress to the individual. And so it's much that same feeling of trying to hold your breath. The difference is when you're holding your breath, you may pass out from lack of oxygen, but ultimately your breathing centers in your brain take over and you start breathing again. You cannot hold your breath until you die. So when you're feeling that holding your breath, if you've done it above water, some people do it underwater, you as you start to run out of oxygen, you may have that kind of anxiety feeling or that feeling of fear or anxiety that you have to breathe again.
All right, we've got about a minute left before we need to hit a break. Seema, I want to go to you first because of your expertise in forensic science.
So I thought this is a good clip that you played because it goes directly to one of the aggravating factors in that it describes the brutality of the killing. It describes how if we are losing breath and then we're like struggling to catch our breath, so you're really, you can see that what he was doing to her in that moment and that she couldn't catch her breath and he was just, it was torturous. It was not, you always say like, oh, it was a painless death or they died in, this was a painful death. That whole choking, the suffocation. Then he goes and stabs all of our major organs. Every major organ was stabbed. Heart, lung, liver, all of it.
Heinous and cruel.
Mm-hmm.
That's an aggravating factor.
The word. There you go. Bingo. Well, I want you to stay put. Much more to talk about when we come back. Have to hit this quick break right now. The big question, will Scott Nelson be sentenced to death for his actions, or will the jury recommend a sentence of life? And should he take the stand? If he wants to, will his defense team be able to stop him? Also, Kevin Spacey's accuser dropping the civil lawsuit against the actor. We're back with the legal analysis on that for you right after this. You're watching Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us. This is our daily sidebar. Got my wonderful colleagues here on the couch. Seema Iyer, Vinny Palatino, Udita Walde, dissecting the Nelson case. The biggest question is probably, will he testify again? Made quite a spectacle of himself during the guilt phase. He's alluded to wanting to get up there again during the penalty phase. Is there any chance his legal team can talk some sense into him and stop him from doing more damage than's already been done?
I don't think so. I mean, during the outburst, he was feuding with his legal team. He was telling them what to do, like he's in charge. He's the smartest person in the room with his 80 IQ. So,
God.
Oh, did I say that or just think
You
that?
said it out loud, actually.
But anyhow, I think he will. He's written that he's going to do it. He's said it in court that he's going to do it. So why would we not believe him?
However,
that's right. He does lie.
Okay, but I just want to point out that that outburst, that second outburst when he was like mistrial now, it took his defense team only 10 minutes in the back in the pens with him, and then 10 minutes later, which I think is a pretty short time, he came out. He was very.
They promised him food.
That must
right.
That's my guess.
Is that it?
Gave him a cookie or something.
Let's not start that.
I know, let's not start it
I'm
because
just saying.
Julie's going to go off on a tangent about the food thing. So wait, just hold on.
I know.
We got to stay on the focus. But I do think that they are having a better relationship than the very beginning of the trial. But at the same bottom line, I think that he said he's going to testify, he will testify, and they can't. And I also think it's important just for our viewers to know that ultimately the decision to testify is the defendants. Right. The decision to call certain witnesses, like the fact that they called Gravette and other witnesses, that goes to the lawyers. So lawyers are in charge of strategy, and he's in charge of whether he testifies and shoots himself in the foot all day long.
Mm-hmm. You do.
I'm going to believe him when he says he's going to testify. I said no in the guilt phase. I said he was not going to get up on that stand. I do believe that he is going to get on that stand, specifically to tell the jurors that Ken Nunley is wrong about who he is. I think he is stuck on the fact fact that he was called a racist in front of 5 black jurors, and I think that bothers him to no end. He was focused on Julio Dominguez in the guilt phase. I think he's going to be focused on Ken Nunley in this phase, and we're going to be hearing a whole lot about.
He can't just talk about the prosecutor. It's going to be objection city.
Of course not. But we're talking about a guy who doesn't care about what questions are being asked. He's going to go up there because he's got something to say, right? And his lawyers are going to allow him to do that. And now on cross, I don't know what that's going to be like.
And if he says he's not a racist, can the prosecutor whip out some of those letters with some of the
that
things
we've
that he's
seen?
written?
I think so. Yes,
words we can't put on TV.
We can't put them on TV, folks. Sorry.
Oh yeah, you know they've got that
Plethora of bad
document right there, ready to go, copy, and I know, ready to marry him to that document, absolutely, if he does. I mean, just so disgusting. And I feel sorry for his team. I think they've done a great job with the heinous facts that they have. And it's a hard job to do, and I think it's important for us to talk about it too, because a lot of times folks will look at the attorneys representing a client like that and say, how can you do that? And it's a constitutional requirement. This is something he's entitled to, the document that we're founded upon in this country. So I think it's important to acknowledge the great work they've done, the research, the digging, the trying to handle the facts as best they can with a very combative, insulting, narcissistic, probably also psychopathic defendant.
I'm saying though, we're also humans. Like, as a defense lawyer, listen, I've been there, like this close to a client who gets aggressive, and it's scary. It is scary. And I've had clients that have attacked court officers or bailiffs, however you want to call them, and these bailiffs are my friends. And one in particular was a guy who was out of work for 3 years because my client injured him. And it is scary. It's scary because even that moment, and I know I told you, Julie, when he said, blah, 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 I want a mistrial. And then he said, mistrial now. And he banged the table. And Chelsea Simmons was this close to him. I shuddered because I know what it's like to feel that way.
You're right. It absolutely was frightening. Well, we'll be talking much more about him in the coming days. So lots more to say. Thank you all. Let's switch gears now. Let's focus on the Kevin Spacey case. So this may have come to a surprise to many people. The civil suit has been dropped. The civil suit, now the criminal case is still pending, that is still in court, but his accuser also had a civil suit going, chose to drop it before the criminal case has been resolved. Any educated guesses as to what we may be able to make of this and what we may see here on out?
I think it's telling for the criminal case because I know a lot of times criminal conduct can give rise to civil litigation, right? And usually a criminal conviction will strengthen a civil lawsuit. Here you have someone who is voluntarily dismissing a civil suit, and in civil court you have a lower burden, right? It's more likely than not that the defendant committed a wrongful act. So if you have that dismissal with prejudice, which means it can't come back out, right? It's dead and gone. That tells me that there's some skepticism in terms of the evidence for the criminal suit. So I wouldn't be surprised if the criminal charges were next.
Well, I think the accuser, there's an issue also with his phone. With these text messages, the phone is missing. They were ordered to hand it over, and they haven't been able to hand it over because they don't know where it is. So I think you take that with this civil suit dismissal. And the other thing with civil suits is, discovery is wide open. There's anyone can be deposed and subpoena, and you end up getting all this information. So maybe the accuser and people around him don't want certain things exposed, which again would undermine the criminal case.
But now the question is, during the criminal case, when they cross-examine the alleged victim, will they be able to ask about the civil suit? Because that's one thing I was thinking. So if this, you think yes? So,
I think absolutely, yeah. You filed the civil suit, right? Oh, yeah, but I dismissed it. Okay.
But then is he allowed to explain why he dismissed it? Because
probably
right. So if there was no civil suit, that would help the victim's case because it looks like you're not looking for money, right?
Sure.
But now that it's been dismissed, is it going to make this whole convoluted.
Exactly.
Think about Bill Cosby, right? People thought that he was guilty because he settled these civil suits. And people in general think that when you settle civil suits, there's some level of guilt there, right? When that shouldn't be the case, and that is not the case. Here you have a civil suit that never was settled. It never came to some sort of resolution. It was just voluntarily dismissed.
Right.
Could that mean and signal to people that Kevin Spacey is actually not guilty?
I know,
of
right?
Maybe.
Yeah, good point.
Maybe.
Right.
But he's got other
But
accusers.
I'm
though.
just saying,
he's not
yeah.
he's not out of the woods yet.
No,
maybe
right.
for this particular case and this particular victim, but he's apparently gotten, a whole lot of other accusations that he's
Right.
got to filter through. So.
I mean, I think we can't stress enough how odd this is because,
odd.
I'm sure we've all been prosecutors here. How many times have you had a case going in criminal court you're handling and you have a civil attorney come up to you, so I represent your victim and and you'd have to politely say, that's great, but that doesn't concern me. So, you can go have a seat in the courtroom and I'm going to do my business and do what I need to do under the law.
And by the way, your civil suit
Right.
has just harmed our criminal case.
Yes, exactly, right, yeah.
I mean, it's just really, and because of that, the reason why they're waiting and watching for criminal cases to be disposed of is because they think if they get the criminal conviction, like you pointed out, it's a much higher burden. A judgment in civil court would be a matter of damages then for them. It would be, you've got the criminal conviction with a high burden. Of course I'm going to meet my burden here. So this is very odd. We're going to keep a close eye on it. Seema, Vinny, Yodit, so great to get your legal expertise. You guys are the best. Just ahead, we will continue our coverage of the penalty phase of the state of Florida versus Scott Edward Nelson. Does the evidence so far in the penalty phase of this trial point more strongly toward a life sentence or for Scott Nelson to receive the death penalty? And in case you missed it, you can watch the opening statements from the penalty phase, the victim impact statements from Jennifer Fulford's children and her husband, Robert Fulford, and all of our most recent coverage for you of this case. It's available both on the Court TV app and on our website, courttv.com.
Tonight on Court TV.
8 years ago today, Casey Anthony was found not guilty of killing her own daughter, Kaylee Marie. It was the trial of this century.
And you will go to jail for child neglect for the rest of your freaking life.
And we're taking a special look back at the most memorable moments of the Casey Anthony trial with the man who presided over it all, Judge Belvin Perry.
Closing arguments with Vinny Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant, and we are so glad you're with us on this Friday. Scott Nelson was found guilty of first-degree murder for killing beloved nanny Jennifer Fulford. And now the jury is deciding whether to send Nelson to prison for life or impose a sentence of death. The penalty phase is well underway, and Scott Nelson's life is hanging in the balance. Prosecutors had their turn to convince the jury that Nelson deserves to die for this heinous crime. Now, the defense is putting on evidence of what are called mitigating factors, factors that could potentially save Nelson's life. During opening statements in the penalty phase, the prosecutor listed some aggravating factors that would presumably support a sentence of death for Nelson. So today, we're taking a look at both sides. For instance, the state says an aggravating factor is that Scott Nelson was already a convicted felon. Let's watch.
The first aggravating factor that the state believes applies, that you will find beyond a reasonable doubt, is that Mr. Nelson has previously been convicted of a violent felony.
All right, and there's more. Nelson terrified employees at a bank that he robbed back in 2010. Let's listen now to what Carol Turek had to say when she was on the stand.
Those directions were that I was to get somebody in charge, and that he had a bomb and that he would detonate it, and I had to wait 30 minutes till after he left or he would detonate that bomb, and he wanted cash from our vault.
All right, I want to bring in our wonderful guest we have in the studio to help me discuss these aggravating factors. Criminal defense attorney Eklund Mercy joining the bunch, Lieutenant Colonel Adam Lee, and criminal defense attorney Michael Bixon. Thank you all so much. Okay, let's talk about these aggravators, starting with the fact that he was already a convicted felon, did the bank robbery, was threatening to blow up the bank. This is a bad robbery, and he was out on federal probation when he committed this crime involving Jennifer Fulford. Have the prosecutors established this as an aggravator? Eklund.
I don't think they did. They actually just put it out there, but it was when the defense got it back, they were able to rehabilitate it. The robbery happened with his father. So his father, there
were two.
So
two robberies.
The two robberies, but the robbery, it was precipitated by his father and the issues with his father. So I think what they did was they tried to bring up, oh, well, he was a felon, but they actually opened the door to let the defense be like, there's a reason why he became this criminal mastermind.
Lieutenant Colonel, do you agree with that? They didn't prove the aggravator?
I don't think so. The bank robbery is a federal crime, of course, and so it differs from state crimes. And so I really don't believe that they showed or proved their point as an aggravator in that case.
Michael, what do you think? Do you agree, disagree?
I think they got it out there. He's on probation, parole for the bank robbery case. I mean, it's a fairly black and white thing. You did it, you're on probation, you're on parole. And what's worse is the amount of time, I think, that went by from the time he was released to the time that this incident took place. I think they got it out there. Obviously, the defense did a good job at bringing in the mitigating factors to sort of offset that, talking about his family and so forth and why he might have done it. But I do think that the prosecution has done a good job of actually establishing that.
Putting it out there. It seems like it's an easy one to establish because under Florida law, an aggravating factor is a crime committed by a person previously convicted of a felony and by a person under a sentence of imprisonment or placed on community control or felony probation. So, of course, we're talking about first-degree murder being the basis. You got to have that first, which we do have that conviction. And then we know he's been previously convicted of felonies. 1994 was the first robbery with his father when he kidnapped his father, drove him to a bank, forced him to withdraw $10,000. Then in November, let's see, we're talking about 2010. He's released from federal prison. December 7th, he robs a bank in Daytona, Florida, threatened to bomb the building. That was the one we heard in that second clip there. So he was out, he got out in the springtime, and then fast forward to September when the crime against Jennifer Fulford was committed. So we know he got the felony conviction, he's been out on federal probation. Seems like an easy one, but is it going to move the jury enough? Maybe that's where the trouble lies. Eklund, you're nodding. What do you think?
Yeah, I see exactly your point. Is it going to push the jury to be like, all right, this is enough? The issue is that now we have the armed robbery, we have the robberies, but is it aggravating to the point of, oh, that's what caused this murder? And it isn't. We don't have a connection. The prosecution didn't make a connection. They should have brought in, brought in experts to be like, all right, because of this is where it started, this is why it's connected in this way, and they did not do that.
I think they were trying to show that the robbery had a violent nature to it. Most bank robberies don't produce a weapon. You know, most bank robberies occur when someone produces a note and threatens that they have a weapon that they eventually never show. And in this case, I believe he said he had a bomb or he was going to blow the place up. It's very doubtful that he had one, but there was some intimidating fear there. The thought of it happening in the minds of those people that were there caused fear. So they were trying to bring up the violent nature of the robbery, I believe, and sort of put that along with what he did eventually to Miss Fulford as a sign that he has a violent nature.
Do you agree with that, Michael? Yeah.
So I think it's important to note that these are aggravating factors. It's not like if he was on probation or parole and he committed this crime, then he must get the death penalty. They're aggravating, right? So it's more likely that he'll get it, and it's certainly still within the juror's hands. I think what's the only probably redeeming part about the fact that he was on probation or parole is the fact that obviously he didn't commit a crime of violence, a threat of violence. But if I was the defense attorney on that, obviously I'm going to try to explore as much, well, he might have threatened to use a bomb, but was there a bomb? Did you see a bomb? He didn't use a bomb. So you can sort of go down that road and mitigate it a little bit. But again, I mean, the aggravating factor is there.
Gotcha. Great thoughts from all of you. Now, and there was another bank employee who was working the day that Scott Nelson decided to rob that bank. They also took the stand. Let's take a listen to what Michael Autry had to say.
He said that there was a bomb in a briefcase, and he pulled out the taser, and it looked like it had he tried to modify it or had some wires on it to make it appear to be a detonator, and he said, I'll blow, it's a bomb, and kind of held it to make it assume like that would be what he would be using as a remote for the bomb.
Okay, so does that make it any worse? Lieutenant Colonel, this is to your point, kind of what we saw in that clip.
It certainly does. I mean, if you produce something that even appears to be some sort of a weapon, that's good enough. You don't have to actually have it be authentic. You know, it could be a replica of a weapon, but that strikes fear into anyone who's on the other side of that desk.
You know, how about, do you think that, does that resonate with the jury? I mean, we're talking about crimes past, we're hearing from these employees, like, is it going to resonate enough as if they were in the trial the first time when, you know, hearing these witnesses? We're talking years later down the road. Do you think the prosecutor did an effective job in painting the picture for them? Because it's on the prosecutor, really, to have that witness tell the story, set the scene, really make the jury feel something about how frightening and terrifying that was when this guy came in and did what he did. Eklund.
It just, I don't think they did a good job of connecting the events. That's showing like, all right, this is what led him down the path of no return. This is what made him just a cold-blooded killer. What they did was they just allowed the defense an opportunity to really paint a really vivid picture with all the evidence that they provided. Yes, we have robberies, but guess what? He was on parole when he committed the murder.
Right.
So that means that the government was involved. Somebody dropped the ball. And that's what the defense should be really harping on as mitigating circumstances. He asked his he asked his parole officer on many occasions, help me. Things are really bad, and he did nothing. So I think that that's more of a mitigating factor than aggravating.
Gotcha. Appreciate all your thoughts. So then the prosecutor moved on to the second aggravating factor in this case. The state saying that Scott Nelson murdered Jennifer Lynn Fulford just so he could avoid arrest. Let's watch.
Killed Jennifer Fulford so she would not testify against him. Those facts establish beyond a reasonable doubt the avoiding arrest aggravating factor, which is that the murder was committed for the purpose of avoiding arrest. He did not want Mrs. Fulford to testify against him, and he told you that in his statement.
Okay, want to get your thoughts on that? Avoiding arrest, is this enough of an aggravator for the state? Michael.
It's a maybe. I think that this is one of the more weak aggravating factors that they have, because even if he didn't want her to testify against him, is that the sole reason why he killed her, right? Was that really the main reason, or was it just for, I mean, obviously there's countless reasons, but we don't know for sure, was that the sole reason why he actually did it? You know, honestly, I think it's a much weaker factor than him having sort of this long, drawn-out history of being essentially a terrible criminal, because he keeps getting caught over and over and so quickly after coming out. I think that has a much larger impact than this, and mostly just due to the uncertainty of the crime.
Right. Let's watch together his testimony about that. Scott Nelson's testimony when he took the stand during the guilt phase of the trial.
What do you mean by get rid of?
Kill her?
No.
Drop her off?
I had no
duct
intent.
tape and zip tie her?
Miss Burdick, I really think you have this all wrong. I never intended to kill that woman. It was not in my heart to do that. It wasn't what I had planned. I didn't want to kill that woman. She'd never done anything to me.
Right. So you drove her, though, all the way to Disney in the back of her vehicle for a purpose.
Yes.
It wasn't just for no reason, correct?
Yeah, you're right.
At some point, did you have to turn her over one way or another to complete what you had brought her there for?
Ma'am, I never brought her anywhere to kill her. That's something you're trying to
Why'd you put her in the field?
Should I have dropped her off in front of OPD?
Why'd you put her in the field?
Asked and answered.
He
Overruled. To leave her there. Not to kill her, to leave her there.
to leave her there.
What did his testimony do to that aggravating factor? We'll be back with more coverage for you of the penalty phase of Florida versus Scott Nelson after this break. Also, we'll be taking a deeper dive into those aggravating and mitigating factors presented in this case. Don't go away.
Hear my prayer, Lord. I lift my voice. I'm coming home. It won't be alone. Forgive my wrong and save my soul. I'm coming home. It won't be alone. As I walk through the valley of the shadow of
This is Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us on this Friday. Scott Edward Nelson was convicted of first-degree murder for the 2017 killing of Jennifer Fulford, a beloved nanny in the Winter Park, Florida area. Now we're in the penalty phase of this compelling case. The state has provided what they hope are aggravating factors for the jury that they believe Nelson should pay for his crime with his life. The defense, though, trying to show the jury that Nelson's life is worth saving. They are putting on what's called mitigating factors. But is Scott Nelson his own worst enemy in all this? He chose to take the stand during the guilt phase of this trial, and of course that is his right. We do not know yet whether he will take the stand again. He's alluded to that. So, what motivated him to murder Jennifer Fulford? That is a huge question. The state says it was all about money. Money that he thought she had and he did not have. And it didn't matter to him that he had never met her before. Let's take a listen.
Nelson committed this offense for money. There is no question that Jennifer Lynn Fulford died because Mr. Nelson wanted cash. That is referred to in the Florida statutes, and you will hear it described as the pecuniary gain aggravating factor. Now, that the murder was committed for pecuniary gain. There is no question but that aggravating factor exists beyond a reasonable doubt.
And Scott Nelson made no bones about what he was after. The state did not even have to call a witness to support this aggravating factor. These words from Scott Nelson's own mouth on the witness stand during the guilt phase.
So it was all about the money then? All about the money.
Isn't everything?
Is that a yes?
I had to eat. I'm a human being.
Is that a yes?
You're damn right it's yes.
All right, I want to turn to Eklund Mercy, Lieutenant Colonel Adam Lee, and Michael Bixon for some answers. What do you make of this and what he just said on the stand? Lieutenant Colonel, I'll start with you, please.
He's showing that he's callous. I mean, it was all, he had to eat. So he murdered someone because he had to eat. So that's definitely an aggravated factor to me. I mean, it was all, he said, isn't everything about the money? Right. So in his mind, it was about getting some money to get something to eat. And Jennifer Fulford lost her life for what, $300?
It just makes it even sadder. It makes this horrible crime even sadder. Michael.
I'll be honest, I actually think this is the weakest mitigating factor for them, which might be a little bit surprising, but there's two reasons why. One, it's hard to say that he murdered her to make sure that she didn't testify. And then it's also on the same side of it to say that he murdered her because he wanted to rob her, right? It's really either or. It's hard to have both of those things. Sure. I think to take it a step further, if you were to say on his part, did he murder her so that he could rob her, or was it incident to him robbing her, right? Did he just happen to rob her and then he decided that, you know, I can't have her testify against me, so then I'm going to kill her? I mean, it's certainly hard to murder someone and then rob them. You'd have to rob them first. So was his intent to rob her, and then maybe later on he decided to murder her to make sure that she didn't testify? If that's the case, it wasn't for pecuniary gain. You know, if I'm like a hired hitman and I'm paid money to kill someone, that certainly is.
Right.
But I don't think this is the case.
Yeah, you know, and he may have helped himself on that when he took the stand and was saying that wasn't initially his intent to kill her.
Absolutely.
So he may have helped himself. During the opening statements, prosecutor Ken Nunley said that the fourth aggravator has already been proven and agreed upon by the jury. So let's listen into that and you'll get the explanation.
You have established beyond a reasonable doubt the aggravating factor that the murder was committed during the course of a robbery or kidnapping. That aggravating factor has already been established and is proven beyond a reasonable doubt.
Okay, so I see where he's going with that, Eklund, because the guilt phase has already been had. It's been decided by the jury because they convicted on that.
Absolutely, absolutely. It was low-hanging fruit for that particular point. However, I just do not believe it was because of money. I believe that Mr. Nelson is getting what he wanted. He testified to Mrs. Fulford being collateral damage, that there was a bigger, that there was a bigger purpose. Like, I personally believe, I would not be shocked if he has a manifesto somewhere about rich people and how they should all just go away. Like, he has been staunch, he has been consistent in his hate for rich people.
Right.
I believe that, he has a goal, he has a plan, that his gain is the coverage. He's getting national coverage. God knows who's going to talk to him about certain episodes or anything on Netflix. I think he's getting what he wanted, which is notoriety or infamy in this case.
There's certainly a law against that, though. If he were approached by some movie or media people about that, I believe there's a law against gaining financially from the crime.
From crimes, right.
But
Lieutenant
whether or
Colonel.
not your face gets out there is a totally different
Right,
story.
right.
If all he wants is fame, he's got it.
That may go to his choosing to take the stand to not help himself. The only thing he may have done to help himself is the point we talked about just a moment ago about the intent for the killing. I think that's what the jury might have been hung up on. 4 hours for deliberations. We all thought this would be a slam dunk, the quickest verdict back, and who knows if it was that juror who did the speaking, to the other juror and said I couldn't necessarily vote for a death penalty for this guy and whatnot. I don't know who the holdout or holdouts were, but he may have helped himself ever so slightly. But I think notoriety, infamy, these are probably things central to this. I've heard several people say this guy's a narcissist, clearly, and trying to focus the attention all on him. But that being said, he's quite a gift for prosecutors, having that testimony to use against him. But are they effective in presenting the aggravators, though? That's another. Can they use what he's saying against him? Is there anything you saw in that testimony that you think really jumps out? It's some of the things we've looked at, prior convictions, pecuniary gain, avoiding arrest. Anything that you think he said that might have really sunk him on the stand?
He said all of it.
Yeah.
He said, I did it. I did it. Get me. And he's like, you're going to hear me. My probation officer didn't hear me. My parole officer didn't hear me. The first time I got in trouble didn't hear me. My father didn't hear me. My brother, I didn't talk to him that much. He didn't hear me. Nobody heard me. This was the only way I can get heard. That is what Mr. Nelson is putting out here. And it's working. In his testimony, he has been staunch. Like, he is like, yeah, okay, I did it.
Right.
He has no problem. He is getting what he wants.
Yeah. At one point it was a sick joke. At one point the prosecutor was asking about the comforter and Jennifer Fulford being wrapped in it. And he said something like, I don't know, maybe she was cold. I know she ended up cold. And one of the aggravators under Florida law is a homicide committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. And so I would use his own words and shove them right down his throat. If I'm one of those prosecutors, and it doesn't get any more callous, calculating, cold, premeditated than that. We have 11 days before the crime. He's at the Walmart buying the duct tape, buying the zip ties, I think they've got a lot to work with here. I really do.
To make a joke about someone's condition that they're going to be, like he said, she ended up cold.
Right.
That was him trying to be funny, and we know when a person dies, they lose their body temperature. So he was making a joke there. He used a derogatory term about her when he described going back to the car to get the knife. He said he didn't want her to testify against him. That was his purpose for going in and getting the knife. Ms. Fulford probably would have died because of the asphyxiation from the tape. The duct tape that was around her, they said was so binding that her nose was pressed against her face. So she would have suffocated had she not been found immediately after he left. If he had not stabbed her and she not been found immediately after he left, she would have died from suffocation. She would not have been able to breathe.
Right. All your thoughts are so great. It's great to have your expertise. Thank you so much. You're going to stay with us, and we want you to stay with us at home. Have to fit in a short break right now. We'll continue our coverage of the state of Florida versus Scott Nelson right after this. Welcome back to Court TV Live, and thank you so much for being with us. I'm Julie Grant. Scott Nelson has been found guilty of brutally murdering Jennifer Lynn Fulford. This is a woman who is loved and adored by her family, her friends, everyone who knew her. And Scott Nelson had never, ever met her before that fateful day. Now, after being found guilty of her murder, he is facing the death penalty. Will the aggravating factors of Nelson's crime outweigh the mitigating factors? We know that this crime was particularly brutal. Here's what prosecutor Ken Nunley had to say during the opening statement he gave in the penalty phase.
And moving on to the next to last aggravator we're going to talk about. You heard testimony from the medical examiner, and you heard testimony through Mr. Nelson's confession to law enforcement about how Jennifer Lynn Fulford was terrified, was crying, was begging for her life in the 1-hour drive he took her on from Reed Berman's house in Winter Park to the shadow of Epcot Center. Based upon the cell phone information, we know that was about an hour that Jennifer Lynn Fulford was restrained in the cargo compartment of her own car. These facts, coupled with the medical examiner's testimony, go to establish the aggravating factor that the murder was especially heinous, atrocious, or cruel.
All right, now let's take a listen together to what the medical examiner said about how long Jennifer Fulford suffered before she died.
How long would it take a person typically to lose consciousness if their airway is obstructed in the manner that Ms. Fulford's was?
For most of us who aren't professional breath holders, or like those people who do deep sea diving, it'd probably be minutes.
Minutes?
At most, yes.
How many minutes?
You can try holding your breath yourselves. For me, it'd probably be less than 2 minutes. I'm not sure how experienced she was at holding her breath.
And based upon your training, education, and experience in your observations on autopsy, do you have a judgment as to how long it would have taken, setting aside the airway obstructions for the moment, Mrs. Fulford to lose enough blood to lose consciousness?
Again, I would estimate that at minutes.
If 2 or 3, 3 or 4?
Probably less than 5.
Less than 5?
Yes.
And that would be how long it took her to bleed out, right?
Correct.
So 2 ways Jennifer Fulford could have died in this case: bleeding out from those stab wounds to her vital organs, and also suffocation because there was duct tape wrapped around her entire face, covering her eyes, her nose, and her mouth. Especially heinous, atrocious, and cruel. Have they proven that aggravator, Lieutenant Colonel?
Absolutely. I truly believe they have. I mean, if you look at the circumstances, you have the tape that could have caused death. You have the knife that could have caused death. He did both. Either one, she would be dead.
Mm-hmm. Either one could be especially heinous and cruel. I mean, 2 stab wounds just to her heart. I mean, the other one's her lungs, her liver. I mean, just horrible. Eklund, is there anything at all, the defense can make as far as arguing against this?
I think the issue is that this particular witness, the medical examiner, was kind of terrible.
Why do you say that?
The prosecutor was really trying to get him to talk. Like, what case we're here. We're here for the murder. We're here to talk about she's being bound. Minutes is what you're going to give. Be specific. I would assume that he would do get some medical information to back up. For me, it would be do better. I think they missed an opportunity to really delve deep into the last moments of Mr. Fulford's life. The medical examiner should have been more detailed. He should have been able to say, hey, this particular woman in her age bracket with her medical history would have only been able to survive these amount of minutes. But just saying general minutes, you're not really connecting to the jury.
I agree with that a little bit.
Okay.
There should have been more descriptive information coming from the medical examiner concerning that. He mentioned something about if you're not a professional breath holder. I mean, so who would that be? A diver or someone who was a swimmer maybe? But I don't believe that it ever came out that Miss Fulford ever was a diver or a swimmer.
No. Well, there's another clip, a little more from the medical examiner. Joshua Stefani is the doctor's name. Let's take a listen to this clip, see if this changes your mind at all. In this clip, he's describing what she likely did go through during those last moments of her life.
Well, just the act of blocking someone's airways and nose and mouth, It decreases your oxygen, increases your CO2, so you can't get that CO2 out, and so that can cause anxiety and stress to the individual. And so it's much that same feeling of trying to hold your breath. The difference is when you're holding your breath, you may pass out from lack of oxygen, but ultimately your breathing centers in your brain take over and you start breathing again. You cannot hold your breath until you die. When you're feeling that holding your breath, if you've done it above water, some people do it underwater, as you start to run out of oxygen, you may have that kind of anxiety feeling or that feeling of fear or anxiety that you have to breathe again.
That anxiety, the fear, the description. And I get that, okay, is he the most compelling witness in terms of the way he's delivering that testimony? Maybe not, I get your point. But he is a doctor, he's a scientist. This is, I mean, the science and the forensics he's explaining to the jury. The way he delivers it is one thing, but did you feel like that description helped you agree with the aggravator more, Eklund?
No, I mean, because he's the doctor. The way he delivers it is the only way the jury's going to get it. So he has to deliver it in a way for them to understand. You saying CO2, they can't context clue. They don't know about carbon dioxide. You have to explain to them and break it down. Like, hey, this is what's actually happening. What he did was he went into one fact pattern and then went into another fact pattern. We need to be able to connect. These are the last minutes of Mrs. Fulford's life. This is exactly what she sustained. We don't know that. He talked in hypotheticals. I think he should have done a better job.
Okay, what do you think, Michael? Do you think he did a sufficient job in order to establish this aggravator for them?
I actually think the fault isn't so much with him. I think it's more with the defense team. I think there was a really strong speculation objection there that they never really raised, right, in terms of how long she was holding her breath, how long it took for her to bleed out, because we didn't hear any scientific basis for what happened behind what he was saying, right? It was just, well, it could have been 2 or 3 minutes to hold her breath, to bleed out, and we don't know why he actually came to that conclusion. It's pure speculation, and I think there was a really strong objection for the defense to come out with that they didn't, and I really think they should have. When he starts talking later on about the panic and the fear, certainly he could be talking about that, and I think that it does affect the jury. But I mean, look, it's a hard thing to understand, but there really, I mean, how many murder cases do we have that aren't heinous or horrible, that involve pain and fear, right? Almost all of them do. So to really single this out for that one, factor, that one aggravating factor, it has to be especially heinous. I don't think they did a good job of actually explaining that, and that this was that kind of case.
And we want to look at some sound now from Scott Nelson's interrogation. Let's take a look at that, and then we're going to discuss it on the other side, please.
The minute he drove away, I went out and I rang the doorbell, and Jennifer answered, and I said to her, I said, you have a package on the doorstep here. Sure. And she says, yeah, I know. And she was looking at me a little odd, like, who are you? Why are you telling me this? And that's when I pushed the door and pushed it in. I went and shut the door, and she screamed. Okay. And she was, frightened. Sure. And I had a knife. Okay. So I told her to lay down on the floor, and then I bound her with some zip ties. Okay.
Okay, I know that was a little bit muffled, maybe hard to hear, but what Scott Nelson was telling the investigators was that she screamed, she was begging for her life, she was so upset at what was going on. These are the last minutes of her life. That's what he said in that interrogation tape. Screaming just in complete horror. Again, I know it was tough to hear, but that's what he said, his words. So how did they get around that? I mean, maybe the defense can kind of combat what the doctor was saying with maybe raising objections, like you pointed out, Michael. How do you, I guess, reconcile that with his own words and how Jennifer Fulford behaved?
Well, with the doctor specifically, this is, as Mr. Bixon stated, like, there was missed opportunities. Like, okay, you're going to testify to panic and fear. Then show me panic and fear. Show me that around where the duct tape is, that there's proof of force. Show me that her fingernails are broken, or there's pressure to show that she tried to fight. Show me something to show that the panic and the fear made her body do do something differently, as you are a doctor. So, you know, as a medical examiner dealing with the body, show me what changes in her body that was caused by the panic and the fear. And I think that they missed an opportunity to really do
I agree.
that.
I think if the prosecutor had used some visual aids in that portion of that testimony with the doctor, it would have certainly have helped them and prove their point.
Right.
Because most people, you know, most of us like to see things. We're visual creatures. So
This is true, Lieutenant
to
Colonel.
hear it is one thing, but to see it is another.
Right. Let's take a listen again to a little more. This is another clip from that interrogation video, and Scott Nelson is describing the injuries that he sustained and knowing what he did was wrong.
I knew what I was doing was wrong. Okay. There's no question, but it just, you have to understand, and I know you do, it just, it isn't like some evil demon came out of me. It isn't that. It's just of how many, I got cuts and scratches all over my body.
Okay, saying he had scratches all over his body and he knew what he did was wrong. Again, his words, what better evidence than that to have in this case to corroborate things? Michael, want to get your thoughts.
Unfortunately, I think for the defense team, it's hard to get around that, right? And we've seen throughout the trial that he's very conceited. This whole thing's about him, and he's talking about the murder of an innocent woman. He's talking about the scratches that he got from doing it, and how horrible that must have been, right? On the same token, you hear about the pain and suffering that she must have gone through. It's a bad fact that you have to get out in front of, right? I don't think it's possible for the defense team to redeem him as a person in front of the jury. You can certainly explain to them how he got to that point in his life, from his upbringing, his terrible background, but I think you have to acknowledge at a certain point, yeah, he's a bad person. It is what it is, right? The mitigating factors are still there based on his childhood, the alcoholism, the abuse. We heard about all this. But where he's at right now, yeah, he's a terrible person, but should we be executing him is a different story.
Right, no, most definitely. What I want to do is ask all of you to kindly stay with us. It is wonderful having your thoughts and your expertise. There's so much more to get into. We're talking about just the aggravators now. We're going to get into the mitigators as well. So more gavel-to-gavel coverage for you of the state of Florida versus Scott Nelson right after this. Also, in case you missed it, we just want to remind you, you can watch the opening statements from the penalty phase, as well as the victim impact statements from Jennifer Fulford's children, her husband, all of our most recent coverage. We have it for you on CourtTV.com and also on the Court TV app. You are watching Court TV Live, your front row seat to justice. I'm Julie Grant, and we're so glad you are with us on this Friday. Scott Nelson is facing the death penalty for the kidnapping and murder of a 56-year-old nanny named Jennifer Lynn Fulford. We're in the penalty phase of this trial. So far, prosecutors are laying out aggravating factors of his crime. They're trying to convince the jury that Nelson should receive a lethal injection for what he did. The defense, on the other hand, is showing mitigating factors. Their job is to convince the jury that Nelson's life is worth sparing. So during the opening statements in the penalty phase, the state laid out all of the reasons Nelson should be put to death. We're taking a look at them one by one. Big question, though, is the jury convinced? Here's prosecutor Ken Nunley talking about the sixth and final aggravating factor. Let's watch.
The final aggravating factor that the state will submit to you is that the murder was cold, calculated, and premeditated without any pretense of moral or legal justification.
All right, and again, Nelson may have been the one to bolster the state's case himself. Here's a look at what he said when he was on the stand.
You didn't wrap her in the comforter.
I didn't do that.
Who did it?
I don't know. I didn't do it. Maybe she did. Maybe she was cold.
Say that last line again.
I said maybe she was cold. I don't know.
On September 27th. How long have you lived in Florida?
I don't know. She ended up cold.
You knew we had to look at that clip. That is that one that just, when I think of his testimony on the stand, that's what I keep thinking of, that moment right there. For me, that stood out most to me. Did it you, Michael?
Oh, absolutely. I mean, like I said before, it is almost impossible to redeem him as a human being. He sucks. He's a terrible person. I mean, it's as bad as it gets, right? That's why I think for the defense, you can obviously talk about his upbringing, how he got to that point, but there's no coming back from it at this point. I mean, like, he is what he is, right? I think you have to step out, acknowledge that, but the only thing you can really do is, aside from obviously bringing up his past, is question whether or not this is the appropriate punishment. Because even if the aggravating factors are there, is that what we should be doing in this case? And I think the answer is no.
Gotcha. Lieutenant Colonel, your thoughts on just watching him there and his demeanor?
Just that one statement alone, to me, it opens the door to a death penalty. I mean, you are joking about someone's dying, and her family members are sitting there having to listen to that as well. And it would be hard for me to believe that a jury or anyone on the jury wouldn't find that as a serious aggravating factor in this case. Very serious.
Yes.
It's coming out of his own mouth.
Right. In that way, in that cold, callous way. Like he just, it was disgusting watching him. I think we can all agree on that. Eklund, anything there that's redeeming?
Well, the only thing I can say about with regards to redeeming is that if you can say that her murder, as he testified, was collateral damage, which is, in his mind, she was merely a part of this robbery, that she wasn't a person. He didn't look to her, he didn't testify to, I saw the life leaving her eyes or anything like that, which what we see with, serial killers or like real, passionate type murders. She was just a mean to an end. And if you can really argue that in a tactful way as defense, to be like, listen, she was just a means to an end, killing him is not going to solve anything. I think that's why I agree with Mr. Bixon, is that we really have to address why do we want the death penalty in this case?
Sure. No, fair enough. Great points. I want to focus in a little bit more on Scott Nelson and just that demeanor and how when he took the stand, because obviously this is going to be big in terms, the jury's, they're not going to forget any of that. I'm sure they're replaying it in their minds just like we are here on Court TV. There was a moment where he was talking about the beer bottle. We know that there was DNA evidence taken from that and to link him to this crime. Let's just watch how he was with the prosecutor when asked about that.
You had taken a bottle of beer from the Berman residence, right?
Terrible beer.
You took it though.
Yeah, I didn't, reluctantly.
All right. And drank it and left it in that vehicle?
Yeah.
Okay.
Terrible beer. That's his comment. Terrible beer. I mean, just making a spectacle of himself. Michael.
Just everything that comes out of his mouth is just callous and it's just uncaring. Does it mean that he enjoyed the murder? Is it something that gave him pleasure? Not necessarily. Again, I think that we see a theme with him, and it's being callous and cold and uncaring. Maybe it's possible for the defense team to use that to say that, obviously this isn't something that he enjoyed doing. Maybe it's something that's part of him being, bad, yes, a terrible person, yes, but again, he didn't derive any type of pleasure from it. But still, I mean, yeah, like I said before, and I've said 1,000 times, he's a terrible person. There's no getting around it.
Right. Oh, he is. I think just disgusting, just a disgusting human being. One of the things that, well, I mean, there were many things that stood out to me in his testimony, but just the calculation and the planning of it being one of these aggravators that they're trying to prove. And we know we talked about the Walmart, the 11 days before, all of that, and how he watched the family. He surveilled them. I mean, they were his target, albeit not a lengthy target. We're not talking a long period of time, but still, you all know premeditation can happen like that. Let's take a look at another clip. This is, again, him on the stand going to the calculation and the perhaps planning of this horrific crime.
What did you buy?
A very long list of material, all different kinds of odds and ends.
All right, well, a lot of it was cigarettes, right? Cigarettes are very expensive.
Yeah, they are.
You bought a pair of blue tennis shoes.
Yep. Yes, ma'am, I did.
You bought zip ties.
Yes, I did.
You bought duct tape.
That'd be correct.
You bought a knife.
I sure did.
That $7 knife is what he used to murder her. Lieutenant, I think this is some of the best evidence they've got for premeditation, that Walmart trip. And they have all the information, the receipts, everything he spent, all of that surveillance video. Your thoughts on, does that help establish calculation beyond a reasonable doubt?
Absolutely. He knew what he was going to do. He was planning on using those materials on someone. So that is proof positive that the plan took place prior to the act, to the violent act. I shudder to think what would have happened had the child been there. Would he have, murdered a child too?
Right.
Or it seems like his intent at one point was to do some harm to the owner of the home. He decided not to go back at some point, according to himself, to his testimony. He was going to go back after he killed Miss Fulford, I believe, to do some harm to the family there that lives in that home. So his plotting and planning took place over a long period of time, which to me shows that he had intent to harm someone. Maybe not to murder, but his intent was to harm. I mean, why have the knife? Was the knife just to cut the tape? I don't know.
Mm-hmm. Eklund.
He has a knife because he doesn't look scary. Like, I mean, you can make the argument that he bought all the things in the murderer's handbag. Let me get the duct tape and the knife and the rope and the new sneakers. Like, he did all of that just for the purposes of a robbery. I didn't think that they proved the fact that, hey, that was an intent to kill, but it was definitely intent to rob. Right. Now, with regards to the items that he did, I think it was, aggravating for the part of robbery, but not to the point, oh, he's a mastermind, he's going to have them in a well somewhere, and putting lotion on themselves. No, I mean, it's just that he did set up the armed robbery.
Gotcha.
Unfortunately, though, for a lot of criminals that intend to rob, they end up killing people. That happens all the time.
Felony murder.
And if
Lieutenant.
that happens as a part of your plan, so be it.
Right.
You may not have intended to commit a murder, but at the end of the day, you did.
Exactly.
You killed somebody.
That is a great point, Lieutenant Colonel. Great points by all of you. I want you to stay with us kindly. We need to take a short break right now. When we come back, more coverage for you of the Nanny abduction and murder trial. Scott Nelson already been found guilty. The question is now, will he spend the rest of his life in prison or die by lethal injection? We're also going to be taking a look at some of the mitigating factors in this next hour in the case presented by the defense. You don't want to miss it.
Tonight on Court TV.
8 years ago today, Casey Anthony was found not guilty of killing her own daughter, Kaylee Marie. It was the trial of this century.
And you will go to jail for child neglect for the rest of your freaking life.
And we're taking a special look back at the most memorable moments of the Casey Anthony trial with the man who presided over it all, Judge Belvin Perry.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
This is Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for spending part of your Friday with us. Scott Edward Nelson has already been found guilty of murdering Jennifer Fulford. She was a 56-year-old beloved nanny working for a family in Winter Park, Florida. Nelson is now facing the death penalty. A jury must decide whether to recommend a sentence of life in prison without parole or death by lethal injection. The defense has been trying to convince them to save Nelson's life by presenting mitigating factors. During opening statements in the penalty phase of this trial, defense attorney Chelsea Simmons had this to say.
This second phase of the trial is very different. And despite the horrific crime that Mr. Nelson committed, this case does not warrant the death penalty. Now, capital punishment is not reserved simply for the worst of the worst, as we frequently say, but for the most aggravated and least mitigating of cases. So far, you've heard most of the aggravation that applies to this case, but you have not yet heard the lifelong history of abuse and mental illness suffered by Mr. Nelson. Our system is meant to balance the value of justice with the balance of mercy. That's why we've been talking about balancing aggravators and mitigators since the beginning of jury selection. The death penalty isn't designed simply for the most shocking of crimes. The system requires that mercy temper justice.
The defense really focusing in on the trauma that Scott Nelson endured during his childhood and the fact that he suffered abuse, both mental and physical. Drug and alcohol abuse as well was present in the home. Let's watch.
Scott Nelson was born in Brockton, Massachusetts in 1964. He was the youngest of 3 boys, and you will hear that his older 2 brothers were much older than him. His brother Jim was about 8.5 years older, and his brother Bob was about 7.5 years older. it was apparent that he was an accidental child, and his parents reminded him of that throughout his childhood. His family appeared normal from the outside, but you'll see that it was anything but normal. His mother, Joan Nelson, was mentally ill and hospitalized many times during Mr. Nelson's youth. She was diagnosed with schizophrenia. She endured electroshock therapy. She was prescribed heavy psychotropic medication that often made her sedated and unavailable. When Scott was born, Joan and Scott did not come straight home from the hospital. Joan was placed in a mental institution, and Scott went to live with a maternal aunt. You'll hear that that aunt already had 3 small children, and that Scott did not receive the attention that he required as a newborn. And that lasted for several months until his mother came home. Scott's father, Larry Nelson, has been described as a narcissist, an alcoholic, an abuser, a womanizer, and having a rage bubbling just under the surface that was constantly present.
James Nelson, Scott Nelson's brother, described for the jury the difficult time that they had when their parents divorced. Let's listen to that.
Can you just tell us how Scott's life changed upon your father leaving your mother?
Oh, yeah. I had moved out of the house. I wasn't around that much. And Scott, his whole life had changed. I mean, economically, it was completely different. My father was not somebody who wanted to give anyone money. That wasn't happening. And Scott probably endured quite a bit with my mother's emotional problems going through the divorce and the fact that someone she considered a friend was now going out with her husband, and there was a lot going on. Plus Scott's age. I mean, he's a young adolescent, and very, very bad time, you know, for a boy like that, and who was attached to his father.
Might Scott Nelson's brother, James Nelson, the man you saw right there, be the one that saves his life? Eklund, want to go to you first. He was compelling, wasn't he?
Yes. He was basically the human part of Scott Nelson. So you wanted to see his heart. You want to see his, the good part of him. That was through his brother. He was definitely just, you could see that the real emotional outburst was when they interrupted his brother while he was testifying, and Scott was like, hey, let him finish. Mm-hmm. So you can see that he has some love there. There's some redeeming value in Scott, which is through his brother. Mm-hmm. So I think they did an excellent job with that.
Mm-hmm. Did you find him to be compelling too, Lieutenant?
I do. I think if you look at this from the outside looking in, you would assume, or you would think that possibly Scott Nelson developed this mental issue from inheritance. Maybe he inherited it. His mother was diagnosed with a problem. His father apparently had his own issues. So putting those two together and producing him, he may have actually inherited this problem. And that's how it all started from that beginning. And listening to the brother, he sort of painted that picture of him growing up in his physical environment as well as whatever he may have inherited just by way of his genetic makeup.
I'm glad you mentioned the physical environment. We have a little clip when he talks about the beatings. And Michael, I'm going to go to you on the other side.
You also mentioned that your father was physically abusive. Can you give me an example of how he was abusive to you?
Well, it ranged from slapping and pushing to where I was hit with a 2x4 on more than one occasion. He would throw things at you. He would get you into a corner and he would beat you with a belt, and he would hit you with the buckle end of the belt. I grew up hearing my mother would repeatedly be saying to my father when he was doing this, don't hit them in the head. My father just lost control and he'd just keep going and going, apparently until he tired of doing it.
Now, we know during certain points of this testimony, some of the jurors were getting really emotional, starting to tear up. Michael, just want to get your thoughts on seeing that emotion, how you would feel as defense counsel, as far as being confident that this testimony is reaching them.
So I think it is, right? And as defense team, you want to put on anyone who can make your client seem more human, especially in the face of a trial like this. I think that his brother's doing a very good job of obviously painting a very vivid picture of a terrible childhood filled with horror and beatings. It's horrible to hear about. I think the biggest problem they have going forward, though, is you earlier heard Ms. Fulford's family take the stand, and I wrote this down because one of the things they said about her was that she never blamed others for the circumstances that she faced.
Wow.
And that to me stuck out so much because it has such a big impact on everything we now hear from any of his family members talking about everything that he's gone through that now leads him to where he is and who he is today. Almost sort of tears it apart. But with that in mind, yeah, I think it's very important for the defense team. Not only important, but it's crucial and almost mandatory for them to put up his family members, to have them talk about what a terrible childhood he went through.
Right. You know, when he was on the stand testifying, I kept thinking how he just seemed evil to me. I mean, just evil. There were certain points I'm thinking, I can't even imagine a human being saying these things and seeming proud of it. And his brother got up there and at points really counteracted, I thought, a lot of the evil that Scott Nelson displayed. His brother really humanized him. We want to show you one of those clips and then get your thoughts on the other side.
Did your mother also rely on Scott for financial support?
Yeah, Scott would give her money and stuff. He wasn't shy about doing something like that. Scott was always a really, really hard worker. I know one time, and that's something that people had always said about him. One time he worked for the summer, I believe it was doing some type of landscaping. And he saved up money and he bought himself a car, and I remember going over there once to visit, and I go, well, what happened to I'm sorry. I said, what happened to Scott's car? He's only in high school, you know, and found out that he had sold the car so he could give my mother the money. And
that
he was like, that's okay.
You said that was when Scott was in high school?
That's correct, yes.
All right, so you see his brother getting visibly emotional there at the kind gesture by Scott Nelson, selling that car that he worked so hard for to have money to help their mother. All right, Eklund, you're nodding as I'm saying this. This really resonates with you, doesn't it?
Yeah, because it's just like a origin story for like a comic book villain. You know, like it's just he had such a, you know, we see that he's a terrible Mr. Bixon says he's a terrible person, but he had a terrible life since the beginning. Like his father was just unreasonably mean, and then we have the Boy Scouts, that situation, and that's enough to unpack there. And it's just consistently his life has had issues in which he could not navigate. So now that brings us up to here. The defense did an excellent job of connecting one life event to another that led to another that led him to here. I think they did an excellent job with that, bringing in the childhood trauma, but connecting it to the murder of Miss Fulford.
What about folks that have way worse childhoods than Scott Nelson and that choose to go a different direction and do good and do better for themselves and treat others better than the way they were treated? Lieutenant Colonel.
That's the problem. That's what we're looking at. We're looking at all the people, the multitudes of people who do not become serial killers or murderers or bank robbers or whatever based on their background. You know, all of us have a story. You know, no one has a perfect, you know, picket fence, dog, you know, house and all that perfect life. All of us have some traumatic issues that we have to deal with growing up, some more extreme than others, apparently. But at the end of the day, that jury's gonna, I believe, they're gonna remember why they are there. They're looking at this situation dealing with Mr. Nelson, but remember Jennifer Fulford, you know, remembering the agony that she must have endured to this person's hands. And so I think that's the most important thing, that they reel it back in, because it's easy for the jury to get emotional and get caught up in this testimony by the brother.
That is a great place to leave it while we head to break right now. I know you're all going to stay with us here in the studio. We thank you for that. We thank you at home for spending part of your Friday afternoon with us. When we return, more live coverage for you of the penalty phase of Florida versus Scott Nelson. The big question, is the defense providing enough mitigating factors for the jury to spare Nelson's life? We're going to dissect it further after this break.
You've used your position and power to pull the wool over everyone's eyes, but I know who you really are.
And who's that?
A killer.
You make it sound so ugly.
Saints and Sinners premieres Sunday night, 9/8 Central, only on Bounce.
It's time to go beyond the headlines and into the courtroom. Court TV is back.
The all-new Court TV, your front row seat to justice.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Thank you so much for being with us. Last week, a jury comprised of 8 women and 4 men convicted Scott Edward Nelson on every count brought against him, including first-degree murder for the brutal killing of beloved nanny Jennifer Fulford. Now, we've been watching the penalty phase of this case, where the state is asking for the death penalty for Nelson, and the defense is hoping to convince the jury to spare Nelson's life. Now, in her opening statement to the men and women of the jury in the penalty phase, the defense attorney, pointed out that Nelson's time in prisons and the conditions that he was subjected to may have caused some mental health issues for him. Let's take a listen to some of what his attorney had to say.
So solitary became a unique problem for Scott. On the one hand, he wanted it. It's the only place he felt safe. He didn't belong to any gang or group that could protect him. He doesn't have any tattoos. He often didn't get along with groups in particular because of verbal disagreements and his reputation as a narc. He suffered physical abuse and was raped by a cellmate. He suffered PTSD from the abuse that he suffered as a child and in prison. But at the same time, solitary confinement was taking its toll on Scott's fragile mental health.
Prison consultant Tim Gravett may have supported the defense argument that this would be a mitigating factor for Scott Nelson. Let's take a listen now together at some of his testimony.
In the record that I reviewed, one of the most glaring things that jumped out at me was that during Nelson's time in the Federal Bureau of Prisons, it was documented by one of the captains in a forum where they were trying to move him to a new program, that out of 19 years, he had spent 95% of his time in the special housing unit. And that's kind of unique.
All right, Lieutenant Colonel, I want to go to you because you have expertise in this area, in particular the prison systems. What does that really say? 95% of his prison career in solitary confinement or the special housing unit. Do you think this may have an effect that could be a mitigator for him?
Absolutely. 95% of time in a solitary confinement would only exacerbate mental illness. There's been studies that have shown that when a person spends that much time alone, they tend to develop a psychosis. We are not meant to be alone. As people, we are meant to socialize, and so it's in our DNA, really, to be able to conversate with people on a daily basis. It's part of our hierarchy of needs, so to speak. And so if you're missing that for 95% of the time in 20 years, you are bound to develop some serious issues mentally.
And I want us to take a look together. Thank you for all of that. This is helpful. And then going into this next clip, it gives us some more context. Tim Gravett, for the expert from the prison system, is talking about how Scott Nelson was bullied during his time in prison. Let's watch.
From what I understand and what I read from Scott's background is he made it known that he had cooperated with law enforcement since the age of 14. He made that statement one time. He made the statement that when he tried to go out to the compound that everybody bullied him. He stayed in the special housing unit because he was one of those inmates, and I'm trying to be nice here, he couldn't keep his mouth shut. So he kept himself in a bind. And it may have been intentional because some of the allegations that he made were not substantiated. So sometimes he made up stories to get into the special housing unit. And that's not uncommon. I've seen that before. I've seen inmates actually write what we call a drop note that somebody was going to assault them, write it on themselves and put it in the mailbox. And then we go and pick them up to protect them and come to find out they wrote their own note. It happens.
All right, Lieutenant Colonel, I want to go back to you first again. Manipulation and these tactics to get himself a better situation. And then the snitching. What do you make of this in that testimony, and how helpful is it?
Mr. Gravett is absolutely correct in saying that the inmates do, from time to time, they will fabricate a letter saying that there's a hit out on them. And so you have to take some action. If you're working in that system, and that, whether it be federal or state, you have to take some action because it may be true. You can't take the chance that this is a situation unless you can prove it, and most likely it's hard to prove it. You have to take some action and segregate that inmate for their safety.
Gotcha. No, these are great thoughts. I appreciate you sharing your expertise in this area. And then, Michael Bixon, I want to turn to you. What about the snitching? I mean, dealing with criminal clients all the time. You practice criminal defense, as do you, Eklund, Mercy. You both do this. When someone's labeled a snitch, not a good thing.
It's a bad place to be.
Yes.
It is probably the worst thing you can do in prison, honestly. I've had clients who have been assaulted, injured, and just on that alone, it is the worst thing I honestly think that you can do while you're in prison. And if that was one of the things that they were sort of alleging about him, yeah, he's going to be in serious physical danger. So, for him, it's got to be a very tough choice. Do you want to be in that sort of imminent physical danger, or do you want to try to put yourself over in solitary, which is probably going to drive you even more crazy? And in terms of decisions to make, it's probably one of the toughest you could.
Right. This is so great getting your thoughts. I want us to watch a clip together. Again, this is more of Tim Gravett, the expert from the Federal Bureau of Prisons, talking about the gangs that did not like Scott Nelson. Eklund, I want to get your thoughts on the other side, please.
Can you tell why Mr. Nelson was often housed administratively for his protection?
He had issues with the white gangs, particularly the dirty white boys, who are a large group in the Federal Bureau of Prison system. And of course, if you make the dirty white boys mad, you've made a lot of other white groups mad. And then in turn, he had the Muslims who were mad at him. When you say the Muslims in a federal system, you're not normally referring to the Muslim religion, you're referring to the Muslim religion and the African American inmates as a group. So I didn't see where he made the Hispanics mad, but he had everybody else mad at him. And so therefore, his choice was to stay out on the compound and take the disciplinary that's going to come from the inmates, or to stay in the special housing unit. And some of the information that I reviewed was because he had testified at a trial in 2002. When you go out on writ like that to a trial, the inmates know that, something's up. And then there were other indications that the inmates saw him as cooperating with law enforcement. And that's a no-no. That's the number one no-no in all correctional facilities. You do not cooperate with law enforcement, you're labeled, and nobody wants you.
So he successfully managed to make everybody, just about everybody, mad at him in prison. Okay, Eklund, anything redeeming about this guy?
Yes, because he was in solitary confinement. It doesn't matter if he asked for it or what have you. If you put somebody in for 19 years in solitary confinement, what you get back is not a human being. You can't. It does not matter if he snitched, because guess what? If we have somebody who is doing questioning for 72 hours, we think that that's morally repugnant. We say that, hey, you can't have them being questioned for 72 hours. Well, he was imprisoned by himself without a soul for over 19 years by himself. And he should be studied. In order for him to piss off that many groups, I've never seen that. With regards to snitching, my clients, I had one client who got greeted with a cup of urine the first day he got into prison because he snitched. And that was just the step in. They also testified that he was raped by a cellmate. He wasn't protected. And so it's like his story for 19 years was either assault, abandonment, or just straight, or threats to his life.
Me.
Yeah, so he,
Woe is me.
yeah, I mean, he was technically he was getting, when you really irritate the biggest white supremacist organization in the prison system, you can't go to sleep. So it's not the same person. That Scott Nelson died a long time ago. So I think if they can make that narrative, I think that'll help him out.
I appreciate the arguments on both sides. You all are fantastic. We need to take a quick break right now. We're bringing you gavel-to-gavel coverage of the state of Florida versus Scott Nelson. Big question, will he be sentenced to life behind bars or a lethal injection? Stay with us here on Court TV Live.
Tonight on Court TV.
8 years ago today, Casey Anthony was found not guilty of killing her own daughter, Kaylee Marie. It was the trial of this century.
And you will go to jail for child neglect for the rest of your freaking life.
And we're taking a special look back at the most memorable moments of the Casey Anthony trial with the man who presided over it all, Judge Belvin Perry.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant, and we're so grateful you were spending part of your Friday afternoon with us. A little earlier in the midday show, we told you about how Kevin Spacey's accuser in a sexual assault groping case that is pending right now in criminal court, just dropped the civil suit that he had filed against the actor. We just learned that the judge in the case had made a ruling regarding the cell phone. Remember us telling you that there was a cell phone that Spacey's legal team was trying to get because apparently it contained some text messages between the alleged victim and his girlfriend sent the night of the alleged assault. And it was ordered that he was to produce the phone by July 8th or appear in court and give testimony on the whereabouts of the phone and its condition. So apparently he was unable to find the phone so far. We know that on a June 19th filing, their family lawyer said that the victim and his family had so far been unable to find that phone. We know today is July 5th, and with that date looming where they've either got to produce it or appear in court and give testimony on where exactly it went or its condition. With that date looming, it seems they have dropped this civil suit. So this new information is providing somewhat of an explanation as to why we have seen that civil suit go away. But still, the criminal case is pending. So this is quite unusual that the civil case has been dropped before the criminal case has been resolved, because it's a much higher burden in criminal court. Of course, we're keeping our eyes on this case. Any new information we learn, we'll pass it along to you immediately. So want to turn our attention back to the Nelson case, the case happening in Orlando, Florida right now. Scott Edward Nelson, he's already been convicted of first-degree murder in this Nanny abduction and murder case. Now we're in the penalty phase of the trial, both the prosecution and the defense calling witnesses to the stand. The state, of course, seeking the death penalty for Nelson, the defense hoping to spare his life. Also, we don't want to forget about the victim in this case, who this case is truly about. Beautiful Jennifer Fulford, an innocent woman, a loving woman with no connection to the defendant. She had family and friends who adored her by all accounts. And Scott Nelson violently took her life by stabbing and suffocating her to death. But the big question is, are there enough mitigating factors to convince the men and women sitting on this jury to recommend a life sentence for him as punishment? Or was this crime simply too brutal? Well, the defense attorneys are trying to convince the jurors that Nelson missed out on crucial rehabilitation time while he was in prison for other felony offenses due to the fact that he was in solitary confinement. Chelsea Simmons, one of his attorneys, presented this as a mitigating factor in her opening statement. Let's watch.
Because of the amount of money taken from Larry's bank account, Scott was charged with serious federal offenses, and he was sentenced to 14 years in federal prison. He was transferred to various penitentiaries all over the country and was unable to receive visits from family members for that length of time. He also wasn't held in correctional institutions, which would have provided some kind of rehabilitation, mental illness treatment, substance abuse treatment. He did not receive that. Instead, Scott spent most of his time in solitary confinement, known as the Special Housing Unit, which you'll hear more about.
All right, now Simmons called 2 different medical experts to the stand to try to explain how Nelson's physical limitations have impacted his mental state. But then on cross, the state got one of those experts to reveal a gaping hole in his neuropsychiatric assessment. Let's watch.
Whatever effect the neurological issues that you have identified with Mr. Nelson may have had as far as effect on his day-to-day life, aren't you?
That's correct. I didn't really speak with him about that.
And you didn't ask him anything at all about the crime with which he has now been convicted, did you?
I did not, no.
So you can't opine about the effect of any neurological issues on the crime that Mr. Nelson has been convicted for, can you?
That's correct. Only that they were likely present.
All right, turning to this wonderful team of brilliant legal minds. What do you make of that? What do you make of what the state was able to do there on the cross-examination? Michael, I'll turn to you first, please.
They took away the link between what they had established as some type of, psychological condition, between that and the actual crime. And I think that was very important for the defense to have, and they destroyed that link. They said that even if he had some type of condition, is it what actually caused him to commit the crime. Look, I think in all reality, this is something that should have come up much, much earlier in the trial. We know that it was a missed opportunity for the defense to bring up any type of psychological impairment defense. Unfortunately, they weren't able to. And now, is it too little too late? It's hard to say. But I think the prosecutors did a great job at taking that link and just demolishing it.
Yeah. Lieutenant Colonel, what do you think?
I think you have different levels of I guess you could say mental deficiencies. And in this particular case, I believe we have someone who is not to the point where they don't understand right from wrong, and they are capable of understanding why they're there. They're not incompetent as far as being able to stand trial. And in this case, clearly, I think that they're having a problem convincing, or they, at least me, that Mr. Nelson is not capable of knowing his actions and knowing the consequences of his actions.
Knowing right from wrong, that is key. Let's look at another clip from Dr. Robert Woe talking about alcohol and cocaine and how that could potentially damage Nelson's cognitive abilities.
Were there factors that you know about Mr. Nelson's background that you also know could contribute to these cognitive deficits?
Yes.
Can you tell us about those, please?
So we talked about the head injuries. Part of this is developmental. So anything occurring in the developmental period, i.e. up to age 25, can cause disruption in that system that we're talking about. There was a significant amount of alcohol consumed during the developmental period, a significant amount of, and further, I believe, a significant amount of cocaine, which also affects central nervous system development and functioning. We know that trauma witnessed or experienced directly causes these types of problems in the development of the central nervous system.
What do you mean by trauma? Is that
emotional, sexual, physical trauma?
All right, seemed like some very helpful testimony to the defense. Eklund, want to go to you, defense attorney. What do you do with that information?
Well, you just make it, I think it's the mitigating factor. I think his time in prison was the mitigating factor to get him out of the running for the death penalty. He was a victim of rape. Prison rape, if that will imprint anybody's psyche, that alone, and then add almost 19 years in solitary confinement, either if he requested it or not. After the first, second, or third request, he's no longer that same person. That alone just takes him out. That is definitely mitigating. No other person, I know the argument is, well, we have people who've been through things and still don't kill people. Well, how many people have you known been through prison rape and then 19 years in solitary confinement? It's not the same person. Mr. Nelson was doomed from the beginning.
You make an excellent point. And at one point in the testimony, I remember Scott Nelson blamed the government, blamed the system, said, they turned me into an animal. I mean, this guy's a self-admitted animal. Lieutenant Colonel, what do you make of him shifting the blame to other people?
That's what people do in his situation. One thing that I really wanted to delve into is the federal, where he was imprisoned, did they play by the rules when it came to allowing him recreational time out? During that 95% of the time he was in prison, were they playing by the rules? Was he spending at least an hour or two out of his cell being able to play basketball or whatever the case may be, to free his mind from that box that he was in? That would go a long way into determining, how deep his psychosis would have developed. Because if he was in that cell, 24 hours a day without being able to come out, then of course he's going to be much more damaged than a person who's allowed some time out as much as possible.
Sure, I appreciate those points. And let's take a look at some other testimony that goes along with this. Dr. Mark Rubino took the stand, another one of the medical experts called by the defense, saying that Scott Nelson had a habit of banging his head against the wall.
Then another source of head injury was when he was about 16, he started banging his head. And banging his head was, he'd basically bang his head even then and when he was in federal prison. He was known to bang his head. That's not normal.
No, certainly not normal. Michael Bixon, what do you do with a fact like that? Certainly helpful to the defense case and showing that this guy is going through a lot of trouble, starting at an early age.
Absolutely. And we've seen, like we talked about earlier, this terrible childhood, and it just sort of escalates as he gets older, and it's sort of compounded by some of the choices that he's making. It just gets this snowballing effect of worse and worse and worse, bad childhood, bad teenage years, to bad time in prison. And it seems like it just sort of compounds all of his mental conditions that he has. And everything just sort of becomes worse over time. What I'd like to see is then put him on, he's going to take the stand whether, what they actually want to put him on there. Sure. But when he takes the stand, making some type of link that the prosecutors were able to take away when they had the expert on the stand. And if he's able to do that, I think it's going to do wonders for his defense team. I just don't know whether or not he actually has enough control to do that.
That is a question that remains to be seen. Let's look at another clip. This is a little more from Dr. Rubino, essentially talking about the brain injuries and then what can come from that. And I want to get your thoughts on the other side.
Yeah, brain injury typically causes impulsiveness, loss of appreciation of right or wrong, or impaired, planning. Planning is impaired. Not necessarily they can't plan. It's just when you're planning, you're not thinking of all the potential problems along your plan because you're impulsive and you're not processing right or wrong as you're going through your planning.
All right, I want to go back to you, Lieutenant Colonel. He's talking about the loss of the appreciation of right from wrong. And you've said this has been clear to you. It's been established. This guy knows right from wrong. What I'm thinking, hearing this doctor, I'm thinking, okay, well, if this is the case, why didn't they raise an insanity defense? which the substance of it would be he did not know right or wrong and could not appreciate his actions. They didn't raise that. So for me, and again, this is getting a little bit into the legal intricacies, and I know our wonderful viewers at home love this. So I wanted to just ask you, did that thought run through your mind too, like it did through mine? Like, okay, now they're raising this in the penalty phase.
It did, but it's problematic when you have a defendant that makes a statement that he knew that he had done something wrong. That's where it would be hard for the defense to go back to that and say, well, we have this doctor saying he was irrational, he was impulsive, his ability to know right from wrong was impaired, but yet you have your defendant making that statement, I knew I did something wrong. So where do you do, just like splitting that hair, where do you go, right or left?
And that's probably why the attorneys, in terms of strategy, didn't go that route, because they've got the, would you agree? You both are criminal defense experts. Yeah.
Because you can't call it with Mr. Nelson. You don't know what he's going to say.
Right.
So you have no idea. You have a firecracker right there. You don't know what outburst he's going to do. He's blowing kisses. He's doing off-comment jokes. You have no idea.
Right.
And then again, the defendant does have a voice with regards to legal strategy. So if he says, hey, we're not going to do insanity defense, then you guys can't do an insanity defense.
Right. And Michael, can I get your thoughts just briefly on that point, and then we have to
Sure.
get to
So
another
I
clip.
think that, should they have tried to go that route, or at least introduce some more about it in trial? Yes. How much they were limited and how much their hands were actually tied by having him as a client, as a defendant, I think that was the big obstacle for them in dealing with it. And we know that he was pushing the trial. Did they have enough time to actually sort of put that defense together? I don't know.
Right. Let's take a look. The defense witnesses revealed a number of really alarming facts for this jury, and that may have even been missed by the jury. I don't know. Cliff Benson, Nelson's childhood friend, his best friend, testified, telling them that Nelson confided in him that he was molested as a child. Let's watch.
Well, Scott and I were together one day, and this guy, Gene Valley, he used to run an ice skating rink in town. And he was known for trying to molest boys. And one day Scott confided in me and mentioned to me the fact that he tried touching him.
All right, want to get your thoughts on this. Michael, since I left off with you, and I didn't mean to rush you there with your answer, but tell me, what about this fact? This is a pretty important fact coming out, if it is in fact true.
Absolutely. I think it goes more towards his development and how he turned out to who he is, as we've all acknowledged, he's a terrible person, but, what got him to that point. And I think this is very important for that.
Yeah. Lieutenant Colonel, any thoughts on that and hearing that? Do you think this is going to tug at the heartstrings of this jury?
Of course it will. We all have, like I said earlier, we have that story. If we don't have the story, we know somebody who has the story. And so we can't help but empathize to a certain degree with him in that situation. And we know that of course, that his time in prison just exacerbated all those bad things that happened to him prior to becoming an inmate or a ward of the state.
No, I appreciate that. Necklin, I want to get your thoughts. After this quick clip we want to play, this is some more horrific things the jury learned about Scott Nelson's father forcing his mother to have sex. Let's watch.
We hear that when Scott was young, he often slept in his mother's bed with her. That his mother and father had twin beds in the same bedroom, and that one night Larry came home, forced Joan to have sex with him in her bed, mere feet from where Scott was pretending to be asleep.
Oh, no, certainly a disturbing fact. We can all agree on that. Eklund, I want to toss this last question at you, because we've been watching this trial so carefully. We know this hasn't come out yet through any other witnesses' testimony. Didn't come out through the brothers. So we're thinking this is going to come out through Scott Nelson, that this is part of the plan with his attorneys to testify to that. Is this something that could help him? I mean, we've all been saying he can't help himself by getting on the stand. Could this possibly help?
Yes, because they're moving the narrative towards his mom. And what I was thinking of as a criminal defense attorney, I was like, at one point, who was going to address victimology? And I think that they are probably setting the stage for probably addressing victimology, because it wasn't addressed at all. We don't know why he picked Miss Fulford specifically. So I think putting that out there and then laying the groundwork for, okay, here's what happened, here's why my life sucked, now here's why I picked this particular person.
Sure, it could, I guess, speak to the motivation, which has been somewhat unclear in this case. I think we can all agree it's been tough to know what exactly motivated him and then what he wants now. Does he want to die? Does he want to live? He's really given a lot of mixed messages in this trial. There's so much more to unpack, and we are so grateful that all of you were here sharing your insight and expertise. Criminal Defense Attorney Eklund Mercy, Lieutenant Colonel Adam Lee, and Criminal Defense Attorney Michael Bixon. Thank you so much. It's been a real pleasure. When we come back, we're going to continue our live coverage of the state of Florida versus Scott Nelson. We're in the penalty phase, folks. He's already been convicted. He is a convicted killer. My colleague Seema Iyer will be joining me next to unpack what we're seeing in this compelling criminal case. Don't go away.